All right, so that's what I wanted to share with you from the dissent in that case, the appropriately scathing dissent. Now let's get to the SCOTUS opinion from yesterday. Supreme Court of the United States, SCOTUS, Greg Abbott, governor of Texas, appealing the underlying decision that favored the League of United Latin American Citizens, which sued against the new map. This is the majority decision written by everybody other than Kagan, Sotomayor, and Jackson. 6-3 decision. With an eye on the upcoming 2026 midterm election, several states have in recent months redrawn their congressional districts in ways that are predicted to favor the state's dominant political party. Texas adopted the first new map, then California responded with its own map for the stated purpose of counteracting Texas. North Carolina followed, and other states are also considering new maps, including most recently, by the way, Indiana. Respondents in this case challenged the new Texas map, contending the legislators' motive was predominantly racial. A divided 3-judge district court agreed. That's the 2-1 decisions we just looked at, the majority and the dissent. And they prohibited the use of the new map for the 2026 elections. With the 2026 campaign underway, the state of Texas and several of its officials applied to this Supreme Court for a stay of that underlying court decision. So the underlying court decision had stopped the new map, and now this Supreme Court order will be staying or stopping the underlying court's order and putting the new map back into effect. Based on our preliminary evaluation of this case, because they were asking for essentially a stay is like a preliminary injunction. You get a preliminary injunction, and then the other side asks for a stay of the injunction, but the standards are the same, and it's a preliminary. There hasn't been a full-blown trial, is the point. Our preliminary evaluation in this case, Texas satisfies the traditional criteria for a stay of an injunction. We should all be familiar with these by now. Texas is likely to succeed on the merits. That's one of them. Will otherwise suffer irreparable harm is another. Balance of the equities is another. And how bad the other side will get hurt is the fourth factor. But the only really important ones are who's likely to win on the merits and is there irreparable harm absent the stay. Supreme Court says Texas is likely to succeed on the merits of its claim that the underlying court committed at least 2 serious errors. By the way, did they have to say the word serious here? No, they could have just said errors. You think they added the word serious, which adds some sting to this reversal because of the manner in which that 2-judge majority treated the dissenting judge? First, the district court failed to honor the presumption of legislative good faith by construing ambiguous, direct, and circumstantial evidence, like New York Times reporting, against the legislature. Second, so the underlying court also did a lot of mind reading. I know the real reason the Texas legislature did this. It's because they're racists. Second, the district court failed to draw a dispositive or near dispositive adverse inference against the people trying to stop the map, even though they did not produce a viable alternative map that met the state's avowed partisan goals. So what they're referring to here is if somebody challenges a map and says the map is racist, that's why I'm challenging it. And the other side says, no, it's just done for political reasons. It's not being done for racist reasons. Well, if the people challenging the map is racist, if they bring into court an alternative map that would achieve the same political goals without the racial disparity, then that suggests that the other map is racist, right? Because they could have achieved their political goals without racial disparity. And we know that's true because the opposing side brought in exactly such a map. Your Honor, here's a map that achieves all their political goals. It's just not racist. They could have done this, and they didn't. That suggests that the only reason they did it their way was for racist purposes. Here's the problem for the plaintiffs in this case. They never brought in such a map. Texas says, listen, our new map is for political reasons. The other side says, no, it's racist. The next step then is for that other side to come in with a map that says, look, we accomplished the same political goals without the racism. And they never did that. Which suggests that it's not possible to draw a map that achieves the legitimate political goals without inadvertently having the racial disparity. And that's allowed. The majority opinion continues. Texas has also made a strong showing of irreparable harm. That's the second of the important factors for a stay, and that the equities and public interest favor Texas. That's the third and fourth elements for a stay. This Supreme Court, quoting now, this Supreme Court has repeatedly emphasized that lower federal courts should ordinarily not alter the election rules on the eve of an election. This is the same doctrine as in Purcell that we mentioned earlier. The district court violated that rule here. The district court improperly inserted itself into an active primary campaign because although the election's not till November 26th, candidates are in the primary process now. Like Brandon Herrera, for example, a friend of mine, is competing against the incumbent Republican in Texas. So that those primary elections are already taking place. Campaigning is already taking place. So changing the rules now causes much confusion and upsetting the delicate federal-state balance in elections. The application for a stay of the lower court order throwing out the new Texas map presented to Justice Alito and him referred to the Supreme Court in its entirety is granted. The November 18th order entered by the United States District Court for the Western District of Texas is stayed pending the timely filing of an appeal in this court. Should a notice of appeal and jurisdictional statement be timely filed, the order shall remain in effect pending this court's action on appeal. So what they're saying here is the people who challenged the new Texas map, the preliminary injunction they received from the lower court, that is frozen. That's no longer in effect. If they want to appeal the Supreme Court decision, they can do that. But if they appeal it, given the time it takes the Supreme Court to do things, will only be actually that much closer to the election. And the legal doctrines that say don't change things close to the election will be even stronger against any appeal. Justice Alito, with whom Justice Thomas and Gorsuch concur in the grant of the application. So Justice Alito wrote his own concurrence here, and Thomas and Gorsuch join him in this concurrence. Alito adds, I join the order issued by the court. Texas needs certainty on which map it will govern the 2026 midterm elections, so I will not delay the court's order by writing a detailed response to each of the dissent's arguments. What's he saying here? He's saying that the dissent's 17 pages of arguments that he has reasoned opposition to every one of their points, and he's ready to go. He's ready to write them. He just doesn't want to delay the freezing of the lower court order. Instead, he says, I offer two short points, which for me are decisive. First, the dissent of Justice Sonia, the wise Latina DEI Sotomayor, of Justice Elena, no, I've never been married, never had kids, why do you ask, Kagan, and Justice Ketanji, I'm not a biologist, how would I know what a woman is, Jackson, does not dispute, because it is indisputable, that the impetus for the adoption of the Texas map, like the map subsequently adopted in California, was partisan advantage, pure and simple, and that is permitted. Gerrymandering for political purposes is constitutional. Second, the clear error standard of review, which the dissent talks about, the dissent basically argues that we should not reverse that lower court ruling unless they made a clear error. We should defer to the lower court's fact-finding. You know the facts, like the New York Times articles? The clear error standard of review that the dissent would use to sustain the lower court ruling throwing out the Texas map does not apply here because the trial court based its findings on a mistaken impression of applicable legal principles. They just effed it up. The majority opinion below simply effed it up. And if they did it wrong, you don't have to defer to them. If they applied the law incorrectly, you're not obliged, the Supreme Court is not obliged, to defer to their fact-finding. What did they get wrong from a law perspective? Because of the correlation between race and partisan preference, litigants can easily use claims of racial gerrymandering for partisan ends. So what he's referring to here is that there does tend to be a correlation between race and voting. African Americans, for example, typically vote Democrat. Now, if you're gerrymandering for political purposes, you're gerrymandering on the basis of Democrat versus Republican, that means you're almost certainly going to have an incidental racial effect when you change the districts. But if there's both political and arguably racial motivations for a change in the map, you're to presume that it's the political that governs. Unless you can eliminate the political rationale, you can't say it was done for racial reasons and therefore is illegitimate. Because otherwise, every redistricting for political purposes, because they inevitably have some kind of racial impact, could just be said, well, you had a racial impact, therefore it's invalid. That the Supreme Court doesn't allow for that. You'd have to show there's no political reason in order to sustain a claim of racial motivation. So because of the correlation between race and partisan preference, whether you're a Democrat or a Republican, litigants, people challenging a map, can easily use claims of racial gerrymandering that were actually for partisan purposes. To prevent this, our precedents, Supreme Court precedents, place the burden on the challengers to disentangle race and politics, show that there was no political motivation. When the asserted reason for a map is political, it is critical for the challenger to produce an alternative map that achieves the claimed political change, as well as the map that's claimed to be racist. Although the challenger's experts could have easily produced such a map if producing such a map were possible, because today you just use computers, AI, to do this, they did not produce such a map, giving a rise to a strong inference that the new Texas map was indeed based on partisanship, not on race. Another argument the dissent made was, we have to give deference to the trial court, the district courts, the amount of time, 9 days they spent on the hearing, and how long, the 160 pages, their opinion was. But who is it, Alito here? Alito writes, neither, should have been a separate paragraph, Alito, neither the duration of the lower court's hearing nor the length of its majority opinion provides an excuse for failing to apply the correct legal standards as set out clearly in our case law. Not only were you wrong, you were idiotically wrong, because the legal standard you were supposed to apply was not ambiguous, it was absolutely clear.